Hi, I'm Kenneth Marcus, Assistant Secretary for Civil Rights at the U.S. Department of Education Office for Civil Rights. The Office for Civil Rights, or OCR, is a federal law enforcement agency tasked with protecting the civil rights of students in schools that receive federal funding. School districts, colleges, or universities, along with other similar entities that receive federal funds, must comply with Title IX. Title IX prohibits recipients of federal funds like these, which we'll refer to as recipients in this video, from discriminating based on sex. That includes the requirement that recipients appropriately receive and respond to allegations of sexual harassment and adjudicate those allegations before deciding how to proceed. The purpose of this video is to address the role and responsibilities of the people who conduct and adjudicate grievance proceedings involving an allegation of sexual harassment. Generally, that person is called a decision maker in the new Title IX rule, which was announced on May 6, 2020. A non-decision maker, such as a hearing officer, the Title IX coordinator, or another individual, may perform certain limited tasks, such as maintaining the decorum of a hearing, but the role of determining responsibility and the remedies and disciplinary sanctions, if any, as well as other tasks such as determining the relevance of questions, is reserved for decision makers. For that reason, we'll generally be referring to the person who conducts and adjudicates grievance proceedings involving sexual harassment, whether through a live hearing or otherwise, as a decision maker. The Title IX rule is effective on August 14, 2020. A recipient's grievance procedures for dealing with sexual harassment must abide by the Title IX rule, including the new rules for decision makers. Decision makers are the individuals who evaluate the evidence, decide whether evidence is relevant in a Title IX grievance proceeding, and to reach conclusions about whether the respondent is responsible for the alleged sexual harassment. Decision makers also determine whether remedies will be provided to complainants and the appropriate disciplinary consequences for respondents, if any. After the initial grievance proceeding, decision makers issue written determinations regarding responsibility, whether remedies will be offered to the complainant, and any disciplinary sanctions that will be imposed on the respondent. When an appeal occurs, a separate decision maker will decide the appeal. A school has wide latitude to use existing personnel, hire new personnel, or delegate the functions of a decision maker to an outside contractor or to a consortium regional center or other group of schools. However, schools themselves owe a duty to ensure compliance with the Title IX rule at all times. These duties include that a decision maker will not have a bias or conflict of interest and will be trained consistent with the Title IX rule as described later. But who cannot be the decision maker? Since the decision maker needs to use independent judgment, the decision maker cannot be the Title IX coordinator themselves or the same person who conducted an investigation into an allegation of sexual harassment. And on appeal, the decision maker can't be the same person who made the initial determinations during the earlier grievance proceeding. Besides these restrictions, the decision maker can be either a single individual, a panel of individuals, or maybe multiple individuals who each adjudicate specific portions of the grievance process, including the issue of responsibility or the precise disciplinary sanction appropriate for a respondent who's found responsible for sexual harassment. In addition, any individual designated by a recipient as a decision maker may not have a conflict of interest or bias for or against complainants or respondents generally, or with respect to a specific individual complainant or respondent.
To help ensure fair process, a recipient must ensure that decision makers, whether they are employed by the school or by an outside entity or consortium, receive appropriate and sufficient training on the definition of sexual harassment in Section 106.30, the scope of the recipient's education, program, or activity, how to conduct an investigation, and the school's grievance process, including hearings held by the school, appeals and informal resolution processes as applicable, how to serve impartially, including by avoiding prejudgment of the facts at issue, conflicts of interest, and bias, issues of relevance with respect to proposed questions, and the introduction of evidence, including understanding that questions and evidence about the complainant's sexual predisposition or prior sexual behavior are generally not relevant. Additionally, a recipient must ensure that decision makers receive training on any technology to be used at a live hearing. Under the Title IX rule, any materials used to train decision makers must not rely on sex stereotypes and must promote impartial investigations and adjudications of formal complaints of sexual harassment. Additionally, recipients must make these training materials publicly available on school websites, or if the recipient does not maintain a website, the recipient must make these materials available upon request for inspection by members of the public. It is the decision maker's responsibility to objectively evaluate the evidence and reach conclusions about whether the respondent is responsible for the alleged sexual harassment. It is also their responsibility to determine whether remedies will be provided to the complainant or the disciplinary sanctions appropriate for a respondent. During the grievance process, the decision maker must weigh the relevant evidence and decide whether it meets the school's standard of evidence for sexual harassment allegations. Determine the relevance of each cross-examination question before a party or witness answers. After a decision has been reached, decision makers must issue a written determination, which includes, among other elements, the facts and reasons for the conclusions reached in the case.
First, let's discuss the topic of live hearings to adjudicate allegations of sexual harassment. Elementary and secondary schools are free to conduct grievance proceedings without any type of hearing, including a live hearing. They may choose to, but are not required to, provide live cross-examination or the other hearing procedures outlined in the Title IX rule. With or without a hearing, after the school sends the investigative report to the parties and before reaching a determination regarding responsibility, the decision makers must afford each party the opportunity to submit written, relevant questions that a party wants asked of any party or witness, provide each party with the answers, and allow for additional limited follow-up questions from each party. At the post-secondary level, a live hearing must be held. Notably, however, if any party requests it, the entire hearing must be held with the parties located in separate rooms, with technology enabling everyone to see and hear each other. At the post-secondary level, schools must create an audio or audio-visual recording or a transcript of any live hearing and make it available to the parties for inspection and review. Additionally, it's important to remember that other civil rights laws must be complied with. So, for example, an individual with a disability who participates in a grievance process must be appropriately accommodated, including with respect to the use of technology and the reliance on visual, auditory, or written modes of communication. Again, it's important to remember that schools may hold these live hearings on their own, or they may coordinate with outside entities or other schools in order to find efficiencies and streamline the way that adjudications proceed. While an elementary or secondary school doesn't have to hold a live hearing, it must still give the parties an equal opportunity to submit relevant, written questions to witnesses and to other parties, provide each party with the answers, and allow for additional limited follow-up questions from each party before the decision maker reaches a determination. Decision makers review the questions to ensure that they are relevant before they are submitted to the other party. Other than in two narrow exceptions, questions and evidence about a complainant's prior sexual history are never relevant. These limited exceptions allow this evidence to be introduced when it's offered to prove that someone other than the respondent committed the conduct in question, or if it's evidence about sexual behavior between the parties and is offered to prove consent. At the post-secondary level, the parties' advisors must be allowed to cross-examine other parties and all witnesses. Cross-examination at the live hearing must be conducted directly, orally, and in real time by the party's advisor of choice, and never by a party personally. If a party does not have an advisor, the school must provide, without fee or charge, an advisor of the recipient's choice who can convey the questions that the party would like to have asked of witnesses or another party. No party can ever be allowed to personally question or cross-examine any witness or any other party. Before a complainant, respondent, or witness answers a cross-examination or other question, the decision maker must first determine whether the question is relevant and explain any decision to exclude a question as not relevant. Cross-examination simply means that a party's advisor asks questions that might challenge the other party's statements or allegations. By hearing each party's version of events and hearing each party's answers to questions about their version of events, the neutral, unbiased decision maker is more likely to reach an accurate determination regarding responsibility. Of course, the final regulations protect every person's right to choose to participate or not participate in any part of a grievance process. That includes even the cross-examination process. No one should be intimidated, threatened, coerced, or discriminated against for choosing not to be part of the school's grievance process, and the rule protects individuals against such retaliation. If a party or witness chooses not to appear at the live hearing or opts not to answer cross-examination questions, the decision maker merely excludes that party's or witness's statements and evaluates any evidence that doesn't involve those statements. The decision maker must never make inferences, positive or negative, about an individual's choice not to be cross-examined or to decline to answer certain cross-examination questions. And similarly, an individual's decision not to participate in the process cannot factor into a decision maker's determination regarding responsibility. A school may hold the entire live hearing virtually, or a school may allow some participants to appear virtually with technology that allows everyone to see and hear each other, again, consistently with other civil rights laws that may require certain accommodations.
Regardless of whether there is a single decision maker, a panel of decision makers, or a decision maker from a regional consortium, a decision maker issues a single final written determination that includes the finding on the issue of responsibility, whether remedies must be offered to the complainant, and any disciplinary sanctions imposed by the recipient. The written determination must be contained in one document and cannot be issued piecemeal in a series of documents. The written determination serves the important function of ensuring that both parties know the factual basis for the outcome of the grievance process. Requiring decision makers to provide findings of fact helps verify whether the decision maker is exercising independent judgment and making an evaluation free from bias. The written determination must include the following. A. Identification of the allegations potentially constituting sexual harassment as defined in Section 106.30. B. A description of the procedural steps taken from the receipt of the formal complaint through the determination, including any notifications to the parties, interviews with parties and witnesses, site visits, methods used to gather other evidence, and hearings held. C. Findings of fact supporting the determination. D. Conclusions regarding the application of the recipient's code of conduct to the facts. E. A statement of and rationale for the result as to each allegation, including a determination regarding responsibility, any disciplinary sanctions the recipient imposes on the respondent, and whether remedies designed to restore or preserve equal access to the recipient's education program or activity will be provided by the recipient to the complainant. And F. The recipient's procedures and permissible bases for the complainant and respondent to appeal. The written determination must be based on an objective evaluation of the evidence, and the procedural steps described must conform to the presumption of innocence and the correct standard of evidence. Once the written determination is complete, it must be sent to the parties simultaneously.
A few more notes before we conclude this video. When evaluating the relevant evidence to decide whether or not a respondent is responsible for sexual harassment, schools can choose between the preponderance of the evidence standard of evidence and the clear and convincing evidence standard of evidence. The preponderance standard asks simply whether it is more likely than not that the respondent committed the alleged sexual harassment. The clear and convincing standard is a higher standard and asks whether sufficient evidence has been presented to make it highly probable to be true that the respondent engaged in the alleged sexual harassment. Whichever standard the school chooses, it has to publish that standard in its written grievance process for Title IX and must use that standard for all formal complaints of sexual harassment, whether the respondent is a student or an employee, including a faculty member. In other words, all of a school's Title IX sexual harassment proceedings must use the same standard of evidence. We hope this video has been helpful for providing you information about how to fulfill the duties of a decision maker under the Title IX rule. If you have questions or would like additional information or technical assistance, you may contact OCR's Outreach, Prevention, Education, and Non-Discrimination, or OPEN, Center at t9questions@ed.gov. Thank you for your help in ensuring that our educational system is safe for all students.